I was reading the order regarding the motion to compel the Case and Koslow text messages. If you remember, the judge did an in camera review, which means that he had all of the relevant or in disputed text messages produced to him. He reviewed them in his chambers and then he made this ruling based off of that review. And when I was reading it, I just got a little bit icked. Here we are reading about one of the individuals and their communications with their dad, who's a lawyer. It references conversations about the dog. I just felt like I was really seeing too much, knowing too much as a member of the public about this person's interactions with her dad, who happens to be a lawyer, whether or not some of that was protected or not. And it just made me think that if we are at the point where we are fighting over whether these kind of text messages are relevant to a claim or should be discoverable, then we've gone too far. I mean, the fight, from a legal litigation perspective makes sense. They're withholding it, Lively Team wants it, and so there's a dispute, and so that's why we have the order that we have. But to me, this just shows or says that the team that's asking for this, the Lively team that's asking for this, has no regard for how embarrassing or the consequences of getting this kind of stuff out in the public has. Now, if we were like in a nondescript court in a nondescript place involving nondescript people, and this was a dispute and it was a hotly contested issue, but nobody was paying attention to it, then fine. Then maybe those text messages were important to prove the plaintiff's claim. But here we're digging everywhere. We're drawing in people into the limelight that don't typically live in the limelight, including these people's family members, this person's dog. It just shows that when they're asking for this discovery, there is no regard for the implications that it has for other people. And I understand that plaintiffs' lawyers, just as defense lawyers, have to zealously advocate on behalf of their client. If that means turning over the earth to get relevant information, then they should do so. From a practical human perspective, at what point are you seeking things for the sake of seeking things and embarrassing people versus actually getting the information that you need? So I don't have a whole lot to say. I mean, obviously, not all communications are privileged. If you text me, just because you text me doesn't mean that our communication is privileged. I have to be giving you advice. There has to be this idea that we're in an attorney-client relationship. I have to remind my friends and family of that sometimes. So that's all obvious legal stuff. I don't have a whole lot to say about the order unless you guys have questions about it, but that's what struck me is the ick factor. Are we really here? Are we really here?